Good afternoon and welcome to this 4 o'clock panel on enforcement models with the nice title of Is the Grass Always Greener? And we will look at that. I am Daniele Nardi, I am a Legal Service Officer of the EDPS, and I really have the honor and the privilege to introduce you to really impressive panel today. We have, starting from our far end, Professor Christopher Kuner, who in the data protection world almost needs no introduction, but I will say anyway that he's Professor of Law at the Vrije Universiteit, and he's also the co-chair of the Brussels Privacy Hub. On his left, we have Inge Graef. Inge Graef is Associate Professor of Competition Law at Tilburg University. Then, continuing on the left, we have Cecilia del Barrio Arleo. Cecilia is Banking Supervisor at the European Central Bank, and she is also Associate Researcher at the European Banking Institute. Finally, on my right here, there is Heiko Dunkel. I tried to pronounce correctly the name, but of course I failed, so forgive with me. Heiko is the head of legal enforcement team at the Federation of German Consumers Organization. I will not attempt at pronouncing the German full name of that, but feel free to do that. So welcome in the coziest room of the egg. You are here and you will listen to a panel in which we will try to identify patterns, to identify threads, to identify fil rouge. What does make enforcement of union law effective? Now, for those of you who were here this morning in the panel which was called Less OSS, Less One-Stop Shop, we have looked at the recent approaches to enforcement which the Commission has put forward in the recent proposal. The Digital Services Act, the Digital Market Act, the Digital Governance Act, all these acts that I'm sure you've heard about. Now, this afternoon, we will look a bit more at practice, at experience. If you want, at the wisdom that comes from real life, at the wisdom that comes from enforcement law models, which are there, they're up and running, they have different ages, but they're all there, they're enacted and enforced. And the key, the objective will be to find out what are the elements from other enforcement models from which data protection could learn, because this is a conference which is about effective enforcement of data protection. Now, when discussing with the panelists, of course, we try to find a way to link all those very different fields of union law. And indeed, as most of you who have attended the morning sessions will have realized, one of these threads, one of these common denominators, is the topic of centralization versus decentralization of enforcement. But we will not only discuss that, we will discuss also the driver of change, what led certain enforcement models to be what they are, and we'll have a lively discussion. Speaking about that, I have asked the panelists to be very strict on the timing, precisely to leave time for questions and answers from this audience. And therefore, without much further ado, I would like to start with competition law. And therefore, I would like to leave the floor to Inge. Inge Graef. Inge, inevitably, I have to start with you because the enforcement of competition law perhaps is the oldest of the lot, and the treaty provisions on competition law have been there for a while, for sure. In a way, competition law has experienced a certain move from centralization to decentralization of the enforcement with the growth of the European competition network. But I would say that the role played by the European Commission at central EU level remains rather crucial. Now, how does it work today? The floor is yours. Thank you.
Thanks a lot, and thank you for the invitation to speak here. So I will indeed try to take you through the main aspects of competition law enforcement as we have it today. Indeed, my slides are already up. At the inception of EU competition law, we had a model of full centralization. So meaning the European Commission was the only enforcer of the EU competition rules contained in the treaty that you were already referring to. And that idea at the beginning seemed like a suitable choice because at the moment the EU competition rules were introduced in the EU, there were member states that did not have any competition rules at the national level yet. So the idea was we need a central enforcer to create precedent and to create a competition culture that is consistent across the internal market. However, with the number of member states increasing, the additional cases that the Commission got through the internal market integration, through globalization, the Commission got really a backlog of cases. And that was the moment where the decision was made to change this fully centralized model. And that model has been in place since May 2004, and that is the model that you see illustrated here. So we still have the European Commission as the central enforcer of the EU competition rules. Most important to keep in mind here is that, and this is also the distinction with what we will see, decentralization that was introduced. Most important here is that the European Commission, if it takes action, if it adopts a decision, that is a decision that is binding across the entire EU. Apart from that, since 2004, also the national competition authorities have been given the competences to apply the EU competition rules, so the rules contained in the treaty. So this means that we have a system of parallel enforcement. Both the European Commission can adopt decisions that apply across the EU, but also national competition authorities can apply the EU competition rules. However, when they take a decision, their decisions are only binding for their own territory. So this means if the German competition authority acts, the decision applies only within Germany, legally speaking. So this also means, because of this parallel enforcement that is partly decentralized, that there is no full consistency in how national competition authorities relate to what the European Commission is doing. One example that I like to point here to illustrate this is what happened around enforcement against most favored nation clauses. So Mfn clauses, these are clauses whereby hotels accept not to offer better prices or better conditions on their own websites and on other sales channels. And there is a distinction between wide and narrow Mfn clauses. I will leave that for now. The most important point that I like to make here is that we have seen a divergence in the approaches that national competition authorities took with regard to Mfn clauses. So in 2015, the French, Italian, and Swedish competition authorities decided to accept commitment from Booking.com to discontinue the wide Mfn clauses. But apart from that, also Germany took action, and Germany took a stricter stance. It did not only prohibit the wide Mfn clauses, but also the narrow ones. So this meant that there was no full legal consistency with regard to the approach to Mfn clauses across the EU. So Booking.com decided to apply the commitments across Europe, but because Germany was stricter than the commitments that the three authorities obtained, there was no full consistency in also the level of protection that consumers had when dealing with hotel booking platforms. A side note here is that also at some point national legislators became involved, so Belgium, Italy, Austria and France also decided to take action, but this is on the basis of a legislative decision, so this is not competition enforcement. Then, of course, we wonder, why didn't the Commission step in? Because, as you were already explaining, the European Commission, despite the decentralization, still has a central role, and the idea of Regulation 1/2003 that introduced this system of parallel and decentralized enforcement was that the European Commission should still be there to ensure consistency. So what the Commission did is that it was involved in a monitoring exercise with the national authorities, but no real attempt was made there to come to a common position. So the only conclusion that was drawn was that we should keep monitoring the sector. one way to look at this is that you could say, well, this is an issue, most favored nation clauses, on which there was no consensus at the time. Also, experts did not agree on how exactly we should look at this from a competition perspective. So maybe it was good to have some level of divergence, some level of experimentation. But in order to have consistency of the laws, one could also conclude that the Commission could have taken a more active role in converging what the national authorities did. Then quickly moving over, because there's more examples that one could link to here. Positive examples, I think, of the system is that we often see experimentation by single national competition authorities. So there are so many competition concerns in markets these days that we cannot expect the European Commission to do everything. So good examples, I think, are the German Facebook case, which is very relevant to this community, where data protection was used as a standard to assess a competition a violation, which is now pending before the Court of Justice. Another good example, I think, is the Google News case that the French Competition Authority did, which was about the protection of press publishers. But we also see nowadays that there's also cases where the European Commission tries to coordinate better with the national competition authorities, and where the concerns that they look at slightly overlap. So for instance, in the Netherlands, the Dutch ACM took up a case against Apple, whereas we know that the European Commission is also looking at that. Similar for Amazon, where we have an ongoing competition investigation by the European Commission, but also the Italian Competition Authority already fined Amazon in December 2021. And the Commission, when taking up their own case, they made clear that their case only focuses on the part of the EU that excludes Italy. Amazon actually fought this decision of the Commission, took it to the General Court, claiming that the system of parallel enforcement means that a company should not be subject to two investigations, one of an NCA and one of a European Commission. So this is just to illustrate that I think decentralization and parallel enforcement in competition law has advantages, but it also creates challenges of how you coordinate this and how do you prevent that there is no duplication of resources where an NCA actually in fact does a very similar investigation as the European Commission. So comparing with GDPR enforcement, and I will close with this, the big difference is obviously that in competition law we have parallel enforcement, both a central authority and a national authorities, whereas GDPR enforcement is fully decentralized. A distinction there is that the decision made by the lead DPA applies across the EU, whereas in competition law, when a national authority acts, their decision only applies in that territory. As we have seen, this can create some challenges. I think a good point of this choice in competition law is that NCAs can pick the cases of their interest, whereas the decision in the GDPR, where the DPA of the main establishment of the controller automatically becomes competent. We know that this creates some challenges where small countries suddenly have to deal with a lot of cases, so we don't have that problem in competition law. And also, it should be kept in mind that in the end, looking at the law, the Commission can decide to still remove national competition authorities from a case. But in practice, we see that also the examples that I pointed to about Apple and Amazon show us that the Commission these days seems to be quite happy when national authorities also take up cases and when they can be coordinated. So I think here a general question that comes from this is, what do we think is important? How do we balance consistency, legal certainty that we need, but some divergence and some experimentation might also be very valuable, and there a balance is struck in competition law when you compare it to GDPR enforcement.
Thank you, Inge. I think that's been really on the spot, and it was not easy when you have to speak together about competition law, data protection law. Let us now move again, speaking about coordination, let's now move to a field which is probably not as old, if I may say so, as competition law, and where legislative changes are more recent. Let's move to consumer protection law, and let's also hear the perspective of a consumer protection organization. Heiko, the floor is yours for 7 minutes.
Okay, can I have my presentation?
It will come.
Yeah,
Here it is.
matter. So, given my role as representative of a consumer protection association in Germany, a rather big one, acting as umbrella for a wide range of other organizations in Germany, I like to talk about rather briefly about two different systems of consumer protection enforcement, which are quite different. One of which is our own legal right to enforce consumer protection cases, and the other, which I will address later, is the thing what Commissioner Reinders addressed briefly, the Cpc regulation mechanism in which authorities for consumer protection law enforcement coordinate in actions, but in which we as a private consumer organization play also a certain role. So as you can see here rather briefly, we have in the field of consumer protection law, the EU was rather happy to have a large number of rules and directives and regulations. This is just a few on the first four regulations are the most important for us because we get as an organization of civil rights organization get our legal basis there. It's Unfair Commercial Practices Directive, Consumer Rights Directive, and of course the new Representative Action Directive, which is procedural law for our collective redress cases, and the mentioned Cpc regulation. I don't want to bore you to death with all these details in the German transposition acts of these cases and legal basis, but it can be reduced to three things. We are able to enforce, as a consumer rights organization in Germany, misleading claims, greenwashing and something like this on the base of the Act Against Unfair Competition, which is based on the UGP directive, the Unfair Commercial Practices Directive. And we can traditionally file injunctions for violations of consumer rights when it comes to small print, to terms and condition violations. There's a rather strict German legal framework to enforce violations of this framework. It comes most of the time it comes down to transparency issues, but also unfair clauses in small print. And the other thing is, and there's a kind of overlapping with GDPR, we can enforce infringements of other consumer protection laws. You can name it. It's a wide range of laws, and GDPR is one of it. So there's kind of overlapping system. I will just go briefly into these two different systems. We, as German Consumer Association, are a so-called qualified entity because we are listed in a certain list on German level, and we have enough staff and competence and are long-standing, working over years, so we are allowed to enforce consumer rights in the name of consumers. And when are we doing it? We are doing it when we detect violations through own research or complaints by consumers or assigned cases by Cpc, by authorities. We sometimes get Cpc complaints given to us. And also we are a third party, officially admitted third party in this case Inge mentioned of the German Federal Cartel Office against Facebook. So this is another role we play. What are our drivers when we enforce those cases and when we choose cases? We don't get them automatically. We choose our cases by ourselves. Drivers are, of course, capacity issues, consumer complaints, unsolved legal questions, because we have the notion that we should bring unsolved questions of consumer rights law or GDPR law before the European Court of Justice or higher courts to get decisions. This is what maybe is a difference to most authorities which are only focused on resolving a case. So, does it work? Of course, there are up and downs, like in all systems. We have no investigative competences, which is okay. We can't go into the company and look at papers or something like this. We are before civil courts and have to make our case with our knowledge. So this is maybe more a down. Maybe it's when I wrote this presentation, I thought sometimes it might be better working on smaller cases which are not so complicated, but I think today I reversed this opinion because all these complicated cases before the Irish DPA doesn't work at all, and we have also some rather complicated cases, so this is maybe not the thing. We are independent. We get funding from government. I'm ready now, and we sort of as independent, and this is maybe a difference between other authorities, but also on a European level, maybe on with other European consumer organizations which are not that independent. So the other thing I mentioned is the Cpc Regulation. It's a cooperation framework between consumer protection authorities in Europe. They are restricted to cross-border cases, violations of cross-border cases when for example, when a German company violates consumers in France, for instance, and there's a mechanism. And also they're doing sweeps, which is a concerted action of enforcement 2 or twice a year. We are in these sweeps too as a consumer organization. So yeah, ups are sharing of information on rogue triggers, which are in more than one member states, then delegation of legal action to other more affected member states where the company sits, and there are binding rules on how to deal with these infringements. And they have the right to investigate. Downs, and this is my last sentence, is only infringement of listed laws in the Cpc regulations. GDPR is not one of those laws who can be tackled by the Cpc network, and sometimes rather slow acting when it comes to external alerts.
Thank you, Heiko, for bringing us the perspective of how enforcement works when you really have to do enforcement on behalf of the consumers. But let's take now the institutional perspective from Cecilia. Cecilia, I would like to prompt your intervention with this question. We were discussing it before, so it's not too much of a surprise. Would you agree that the financial crisis of 2008 prompted the creation of a rather centralized system where there is a clear structure, there's a structure of the banking union, and more specifically, there is a structure in the single supervisory mechanism, at least for the Eurozone? But of course, over the floor to you for your presentation. We know that you also have a few slides to show.
Yes. So yeah, thanks for the invitation. Just the usual disclaimer that these are my views and not necessarily those of the ECB or the EBI. So yeah, just to quickly, this is a bit what I'll be broadly cover. So just like a very quick overview of what are we talking about with banking supervision, then just the question of the model specifically, and then tackle this question in connection with the cooperation between national authorities and supranational authorities. So yeah, just moving perhaps to Danielle's remarks at the very beginning. Actually, for those that are not very familiar, perhaps with the setup of EU banking supervision, actually the question of how the SSM was born. This is one of the pillars of the so-called banking union, which was one of the products or one of the children of the crisis. I mean, both partially global financial crisis, but mostly the Eurozone financial crisis, which had this kind of prompted this question of centralization towards the supranational authorities. And basically here we have the legal underpinning of all of this institutional setup is a so-called single rule book that, as we see here, perhaps it's not that as single as it seems, because as a matter of fact, it's made up of these different levels of regulation. So basically, well, the level 1, it's perhaps the most, or the ones we're mostly familiar with. So in the case of banking supervision, it's mostly capital requirements regulation and capital requirements directive. Then we move to level 2, which are mostly all the legal acts that the Commission has delegated into the EBA being the European Banking Authority. So it's kind of the cousin of the ECB in the banking supervision setup, because while the ECB enforces supervision as such, the EBA is mostly the regulator. And then we have this level 3, which are mostly all these soft law instruments in a way, some of which are also done and prepared and issued by the ECB itself. So in spite of all this single rule book thing and the solidity, it seems, from this harmonization perspective, there are still many open loops in a way, because, as I had said here, in the supervision realm, we have directives, and therefore they have like national implementations done in different ways. And also even the regulations, or even the maximum harmonization instrument that we have, also gives space for options and discretions at the national level. And here, these little pictures that you see, it's the latest version of the ECB's guides on options and discretions, which is one of the key policy tools that the ECB has been using to kind of steer this more centralized way of actually enforcing supervision law. Just a quick recap here on how does the SSM work. So basically, the key here is this distinction between significant institutions and the so-called less significant institutions. This distinction is made so that the criteria and the thresholds according to which these two sets of banks are made, it's specified in the SSM regulation. And the key concept here is that significant institutions are directly supervised by the ECB through these joint supervisory teams that we'll see in just a few seconds what this is about. And then the less significant institutions are supervised still by the national supervision, but still the ECB has a role as it says here, as an indirect supervisor. Now we're going to explain a little bit what this means. So this question of the joint supervisory teams, are these joint teams are basically the sort of the core of the ongoing supervision. And these teams are made up of people from, ECB staff and people from the national central banks. For example, I'm a JST member. I don't have any superpowers, so don't worry, because maybe sometimes, I don't know, when you read in the papers, JSTs can do everything. No, we cannot do everything, but it's this kind of joint effort between the ECBs and between the ECB and the NCAs. And we are assigned to different banks, and we carry out this ongoing supervision of the significant institutions. Now, just moving a bit to perhaps the core here of this distinction between what or how the burden is divided between supranational and national authorities. So as we said before, so the supranational authorities, or basically the ECB, carries out the supervision of the so-called significant institutions, while most of the less significant institutions are still under the national authorities. By the way, national authorities can be national central banks when they have the oversight competition, or it can also be a specific case. For example, in Germany, we have Bundesbank and BaFin all together carrying out the supervision. So just to clarify that the concept of NCA is also a bit blurred here. However, the ECB does not stop here. So it's not that the competitions are perfectly divided and this is the of the story. But actually, for example, there are some provisions in the SSM regulation according to which the ECB can take up the competence of some less significant institutions. For example, in case this, little bank poses some threat to the financial stability. And so therefore, it's interesting to see that in spite of this apparently clear division between national and supranational competencies, we have ways in which perhaps the action of the ECB or the supranational authority is a bit pervasive. I mean, being either through, for example, these specific clauses that allow to take back supervision of these so-called LSIs, but also because they exert some kind of moral suasion in a way upon these LSIs, for example, by trying to ensure this much sought after level playing field, that we can maybe agree more or less the extent to which this level playing field is, is actually having some kind of concrete impact in different cases. But it's important to see that actually this is one of the main policy goals that, I mean, after the crisis and actually with the setup of the SSM was being pursued after seeing that the application by the national authorities was a bit like scattered and sometimes difficult to carry out, perhaps in the opposite direction, for example, as the decentralization tendency that Inge was describing before. And then maybe we can talk about like decentralization via jurisprudence afterwards, but just to perhaps wrap it up here in terms of these, in terms of the interaction between the national authorities and the supranational authorities, one aspect that it's kind of interesting, I think, from the ECB side, is that actually the ECB, when exercising its supervisory powers, not only exercises like those powers that are enshrined like in specific EU law, but also enforces those under national law, which is a bit of a particular thing in this regard. So, so here it's like a bit the distinction of the competencies, and yeah, we have some more food of thought for later on. So this is a bit it.
Thank you, Cecilia.
Thanks.
And Professor Kuner, what do we make of it for data protection? We have heard about two systems, a centralized system that went towards decentralization, a system which was the child of the financial crisis, which is rather centralized. We have heard, of course, that those systems are far from perfect. What do we make of it for data protection law?
All right.
First of all, let me interrupt you. A big thank you for being here, because I know that today's been a challenge for you. So really thankful.
Thank you.
Also on behalf of the
I'm
Supervisor.
pleased to be able to be here, and thank you for the invitation to this very interesting event. So I have just really 7 minutes, and I know our moderator is a very strict person, so I need to try to hold to that. So I do have some slides, but I'm really going to run through them quickly, and I've given the EDPS my consent to distribute the slides to anyone who wants them. So please go to him after the panel if you want that. So really, I'm just going to sort of run through these quickly. I should say too, I'm certainly not an expert in any of these specific areas that the previous speakers have spoke on, far from it, even though I'm supposed to draw conclusions from them. So I'll do my best in that regard, but just be aware of that. So first thing, which really I don't need to say too much about, is that there are problems with enforcement of the GDPR. We all know that. That's what this whole conference is about. I've listed just a few of them here with the description and the relevant provisions of the GDPR. They seem to me to sort of fall into two main categories. First of all, there are issues about the one-stop shop mechanism, which is how the EDPB makes allocates cases and makes decisions. And then the second is problems specifically in the member states with enforcement. And the member state level is, of course, where enforcement actually takes place at a concrete level. Some initial observations, I think it was to be expected that there would be some, let's say, teething problems with enforcement under the GDPR, because it really represents a huge change from the previous system of the Directive 95/46. But now we've had several years of experience, and I think that these problems should not be allowed to just continue endlessly. We have to find solutions. What's also important to realize is that the GDPR only harmonizes cooperation, consistency of DPA enforcement, of course, and of course the substantive standards of the law are harmonized. But it does not harmonize national procedural rules. So how the actual enforcement happens at the national level is not dealt with in the GDPR, and thus the current text of the GDPR, I don't think, can provide a a perfect solution. And I would differ here with some things I've heard, for example, from the Commission, saying let's just keep going and things will get better. I think it's also important to recognize the EDPB does seem to be very much aware of these problems, and they've published very recently a slew of papers and documents trying to deal with them. I was wondering, these are issued suspiciously close to this conference. Maybe the conference had some role in provoking them a bit, but they do seem to be really trying to get a handle on some of these issues. So I was trying to think then, what are some of the relevant EU law issues to enforcement? And I've come up here with sort of three of them. The first is what's called national procedural autonomy. So there is no there's no EU general procedural law. EU rights are largely exercised in the member states under national procedural law. This is in the TFEU. And it's important to realize that this concept of procedural autonomy, I often think, is a sort of a misnomer. It's not a right of member states to keep their own procedural systems. It means it's a manifestation of their duty to provide an adequate procedural framework. So each of them has to provide such a framework under its own system, but it doesn't mean that there's some core element of procedure which they can keep as they like at a national level. And there's a very interesting article too by Kuhn-Lennartz in a German law journal that goes into this too, which you might want to look at. Also interesting is that competence for data protection is shared between the EU and the member states. And as with any shared competence, this means that when the EU acts, the member states are then foreclosed from acting. Now, the GDPR has certainly foreclosed a lot of action by member states, but there are also elements of the GDPR where there's a lot of leeway for member states. So my conclusion from this is that for areas that are harmonized under the GDPR, I think that member state procedural requirements may not interfere with the effectiveness of protection under the Charter and under the TFEU and the right to data protection. So there are very clear limits, I think, here. And we've also seen the Court of Justice has been gradually shrinking this concept of procedural autonomy over the years. Then, of course, very relevant issue here is the independence of the DPAs. And this is a kind of a unique, the DPAs are really, and the EDPB are a unique animal under EU law. I don't think there is any other similar body under EU law that is given constitutional status in the treaties. And of course, the Court of Justice has had several rulings on this also. So this, I think, the independence of the DPAs puts certain limits on what can be done also to kind of force them to cooperate better, force them to take action. Then there's also, of course, this issue of the allocation of the regulatory authority under the one-stop shop. There were a lot of very interesting debates during the drafting of the GDPR. You may remember this very entertaining session with Commissioner Reding going against the head of the Council Legal Service, Monsieur Legal, where they were fighting about, is the one-stop shop compatible with EU law? I think it is compatible with EU law within, of course, certain principles, but this was controversial when the GDPR was negotiated, and I think some of the problems maybe with the one-stop shop are a continued manifestation of these continuing arguments about how it should function. Then I looked at some different regulatory models in EU law, of course, of which there were thousands of them. So I just had to kind of choose a few examples. And looking first, there are some examples of decentralized bodies where there is a kind of increasing centralization from having just a network of national authorities like the body of European regulators for electronic communications, then moving to more direct intervention powers like the European Banking Authority, and then more to really having a European agency. And then, of course, we move to another level, which is giving direct competence to an EU institution. The best example of this is competition law, where the Commission has exclusive treaty-based competence for competition rules necessary for the functioning of the single market. Now, none of these, I think, are perfect analogies to data protection because none of them involve these kind of independent authorities with constitutional status like the DPAs, but there are certainly many, many models to choose from. So how could enforcement be improved? I've come up here with sort of three options. First option would be to take the existing system and make it work better through improved cooperation and consistency. And I think this is more than just a wish. This is something that the Court of Justice has required. If you look at the Facebook Ireland judgment, the court says this very clearly. Then, of course, there are these recent initiatives of the EDPB, which is very good, trying to harmonize certain areas. And then there are also soft initiatives, which I think should not be downplayed. For example, the EDPB pool of experts, I think, is a very good initiative, which can also bring in outside expertise and provide for perhaps better enforcement. But I don't think any of these would completely solve the problem. Then my second option would be procedural harmonization through new EU legislation. So wouldn't it be possible to enact some sort of new regulation alongside the GDPR, so not opening up the GDPR, but harmonizing perhaps certain national procedural impediments to implementing rights under the GDPR effectively? And there are many areas where this could be discussed. There is some interesting work going on, like in this project renewal.eu, which was many very prominent EU administrative law experts got together and drafted principles of EU administrative law. And I think this would be completely compatible with the procedural autonomy of the member states if it's done correctly. And then option three, which would be the bigger option, would be to give broader enforcement powers to some sort of new EU DPA, which could, for example, focus on major enforcement actions. So cases that have pan-European major importance and leave other things maybe to the national DPAs. This could also involve, of course, the EU DPA working together with the national DPAs as under the European Competition Network. Who could this be? Well, the EDPS would be, I think, the most logical candidate. Why not? However, this would, of course, involve revision of the GDPR or treaty change, which is not something that many people relish, but sometimes you have to bite the bullet and go for the hard option if you want to solve the problem. So my concluding remarks are, first of all, these three options, I don't think they're mutually exclusive. They could be pursued in parallel, or some of them not, and they're also some are more short-term, other are more long-term. I think it's also very important for the one-stop shop that it has to work well in a sort of self-corrective fashion, so that when there are problems, a lot of the solution has to come within the EDPB. And we've seen this, I think very significant is this decision concerning the WhatsApp Ireland case, the decision of the EDPB. And of course, there's also a general court case involving this decision. Then the Court of Justice will have a very important role to play. So some of these problems may also be resolved gradually by cases through the Court of Justice. There's currently a very interesting case pending before the General Court involving what happens when there are simultaneous proceedings before a national court and a DPA on the same issue. That's something that isn't really answered in the GDPR. And then I just want to point out a looming problem. If you think things are bad now, just wait until all of this new EU data legislation is passed with all kinds of enforcement bodies there. Some of the enforcement responsibility given to the DPAs, some to other bodies and other boards. So let's hope that we can keep our lid on that also, and that this doesn't create further problems. But I think I'm even a bit over my time, so I better turn over to our moderator.
Mindful of time, I think I will just put one question to all the panelists we have today. And I would like this question to be prompted by what you, Professor Kuner, just said at the beginning of your presentation. I noted it down. You said that with the GDPR, some enforcement problems were to be expected, but after several years, they cannot be allowed to continue. Now we have here the example given of competition law, which has been, there are several years of experience, and there's been a move towards decentralization. There are problems, but probably, and I will look at Inge, the system overall works. It needs improvement, but it overall works if we have to be very general, as we need to be in this context. Then we look at the banking supervision and the single supervisory mechanism, and we have a huge crisis that threatened the very existence of the European Union, let's be clear about that, that prompted towards a centralized model. This morning we heard, oh, the GDPR is so young, and I was also one of those sitting in the trialogues of the GDPR, and I don't feel it that is such a small child. I think that in the field of protection of fundamental rights, 1 year probably is the equivalent of 7 years of competition law or 7 years of consumer protection law, and we will come back perhaps if we can on the coordination model, especially in the Cpc regulation. This was all prompted by thinking about, you know, my dog, 1 year of my dog is 7 years, and I think the same goes for fundamental right. Would you agree that indeed there is this urgency, and I also ask, I know it's a big ask for those who are not necessarily expert in data protection law, but the purpose of this panel is to make bridges. Would you agree with what I just said, or would you disagree? What is, do you think that indeed the passing of time and the urge should be considered differently? Shall we start again with Professor Kuner? What do you think?
Yes, well, I don't know how many of you were around Brussels and working in data protection in 1999. That's when I started. And I well remember when the directive was enacted and there were problems with it, and this was always the same view of particularly the Commission, and things worked much more slowly then. So, you know, they waited a long time then to finally, years later, decades later, to propose the GDPR. I think back then this was a more respectable argument to say, let's give this some time. The directive was very new. I think now things move much more quickly. And I also think, you know, we had the financial crisis, we've had the pandemic, maybe we have a sort of data crisis now. Data, the importance of data processing has just exploded beyond any reckoning. I remember back then having to kind of try to convince people this was even an interesting area. And, you know, even in some of the institutions, people just shook their head, but now no one would question this. So I think we have to see this with a bit more urgency than just saying, let's just let this work itself out. As I said, I think it's perfectly fine to say, yes, there are increased efficiencies that can be gained by having the DPAs work better together, by having certainly the Court of Justice coming down with judgments, but I would see this a bit more urgently than saying, let's just give this some time and don't worry, be happy.
Any other comments from?
I would add that if I look, for example, at the timeline in the case of prudential regulation, so in the field of banking supervision, I feel that we have been having this kind of very increasingly like granular, like centralization, I mean, through the different directives that were each and every time a bit more substantive. And then even at the international level, for example, with the Basel Committee, it's the same thing. So at the beginning, Basel I was just a very little document, then it became a monster after some years. So I think that if we take the history, for example, from this field, it's kind of clear that the progression was kind of relatively slow until something prompted. So as now the professor was saying, maybe it's the case that we also need a sort of data crisis to accelerate the things and then come up with a more centralized, or I don't know if centralized is a solution, but actually the level of coordination has been for sure strengthened after these things.
Anything more on your side?
Yeah, to add to that, I think it's also not only important to think about the time it takes, for instance, to make changes in the law. We also know that investigations takes time, which I think is valid for data protection, consumer, and competition law definitely as well. And how I see this is that indeed there is the main aspects are really laid down in the laws. There are some limitations there, but I think there is also a lot of scope for authorities to experiment, to be more bold. I think I agree with you that indeed all these new acts that we have at the EU level create even more confusion about how these different enforcement methods will work together. But on the other hand, if I, for instance, look at the DMA, there is a few provisions also already mentioned by Commissioner Vestager that clearly relate to the GDPR. So maybe looking at from a more idealistic, maybe optimistic perspective is that some of these acts might also address concerns that are not completely the same as data protection, but could help take us in the right direction.
Yeah, I think the urgency comes from two different aspects. One is the matter of law we are talking about, because different maybe to certain other consumer protection laws or other European laws, we are talking about a basic fundamental right, which is also in Article 8 settled. And this is maybe in itself a reason to be more urgent to solve these enforcement problems. And we have a tremendous lack of enforcement. And the other aspect is the kind of infringements we are facing here. We have extremely mass infringements when you look at business models based on real-time bidding and advertisement, which shouldn't be there. They should be forbidden. But there aren't, and we see when you look at this political process of the e-privacy regulation that there won't be forbidden anytime soon. So you have to tackle them with the existing framework, and GDPR is one of it, because you can tackle these legal problems with questions of informed consent, and if you have to. So it's not ideal, but...
Thank you. Let's have a round of questions, because time is really a tyrant here. We have to leave at 5, let's say 5:03. I'm making that up, so just use this time, please. And yes, I am reminded to remind you, if after this session, you can please move kindly directly to the auditorium. Thanks. Thank you, Jofi. Please.
Gianclaudio Malgeri, Brussels Privacy Hub. Thank you for this great panel. I had a question about the relationship between the enforcement of consumer competition and data protection law, because we saw that, for example, for Facebook, since the one-stop shop mechanism was a problem, then we had the Italian Consumer Protection Authority and the German Competition Law Authority trying to do what maybe a data protection authority should have done. How? Oh, because you take some links. Forcing consent is an unfair commercial practice, or abusing of the dominant position if you don't respect consent provision in GDPR. So there are some links, actually. Don't you think that this, which is quite effective in a way, can raise a risk of double jeopardy? Because then they might say, oh, if I am sanctioned for this, for example, Facebook, data protection authorities will not be able to sanction me in the future. So this problem of double jeopardy, I don't know if you have, what do you think of this? Thank you.
Who wants to take on that question? Of course, you know that there is a pending case before the Court of Justice. I think the hearing was last 10th of May, precisely on the concurring competence of competition authorities and data protection authorities in applying the GDPR. Who wants to go ahead? Inge or Heiko?
I was there at Luxembourg in this case, because we are third party to this federal case. And yes, of course, it has all the issues involved in a nutshell, because it's competence of a authority in comparison to another, because the German Federal Cartel Office chose a rather slippery slope into GDPR law. It could have chosen another way, which would be more safe. But my thought after this court hearing was it comes down to the principle of loyalty between different authorities, because they're not doing the same. this is what Facebook said. You are doing the same. Actually, the Irish DPA should do this, but actually the German cartel office is doing cartel law. So and this is a completely separate thing. And we coming into this game with our own cases. We have 8 cases in the last 30 years against parts of Facebook alone. So and many others, and we face the same arguments. You shouldn't not be there because this is the case for the DPA in charge in Dublin. But we are not thinking of us as DPA enforcing GDPR rights. We are enforcing consumer rights and unfair commercial practice law, and coming from there, having a bridge into the GDPR and having some arguments from there. And this is, I think, it's not a problem. It's different areas of law, and it comes down to the EUCG to decide on GDPR questions, and there's no fraction of law, in my opinion.
So an effective cooperation, actually.
It doesn't work perfectly, but it's not that bad.
Okay.
In this aspect.
Thank you. I think that the matter of cooperation would deserve 3 panels on itself, and also loyal cooperation. Personally, I think probably the court is very optimistic when it comes to loyal cooperation in the context of the GDPR. And what the court probably said in the point of the Facebook case that was also quoted by Professor Kuner, is a bit stating a bit what's on paper, but not what's on the ground, which in the end is also the task of the court. Another question, because my controllers are distracted, so we can afford another question. Please.
Is it on? So first of all, thank you very much to all 4 speakers. Like 3 of the speakers, I am not an expert in data protection law. I am an administrative law and the EU administrative law professor at Nova University of Lisbon. My question actually goes in the direction of administrative law and how different experiences of models in administrative enforcement can be useful when considering potential reforms in the GDPR. My question is a bit provocative. I wonder if the focus of our debate should actually be the models or specific aspects of those models. And I'll say what I mean by this. And I'm no expert in competition, banking supervision or consumer law, but from what I know of these different fields, different aspects have been more or less successful and have proven more or less problematic. I think of competition law, and I think, for example, of how long it took for a common competition law enforcement culture to emerge, and only now we're reaping the benefits after 16 years, right? So if you want to create something similar in data protection, I wonder if it will take as much time. In banking supervision, there may be advantages of this dual system of keeping the big players under direct supervision by the ECB, but on the other hand, to avoid the problems of harmonization, right? The fact that the ECB can apply national law and exercise national authorities' powers has given rise to a lot of legal uncertainty because the exact limits of that mandate are disputed. So my question would be, if you think of specific aspects of the models that you just described, what cautionary tales for GDPR reform would you identify? Thank you.
Not an easy question.
I mean, I can just briefly, I don't know, the first thing that comes to mind, thanks for the question, is this aspect in the case of the SSM that we have what's called the common procedures. So, for example, the qualifying holdings or the fit and proper assessments that are initiated by the NCA, and then even in the case of the supervised entities that are directly supervised by the ECB, these procedures are initiated at the national level and then pass on to the ECB. So even though, we have perhaps just like give this very kind of big picture of how the model works, it's true, and this is something that we debated internally, that actually there is no such like centralization or not. I mean, there are like different shades, and actually, for example, in the case of administrative law and national administrative law is one of the cases where you see this different nuances in the model. And for example, yeah, in the banking supervision case, we have the common procedures, and then also some aspects of national law that it was what I hinted before. There is like this kind of shared competence in a way, but where the ECB in any case has issued very clear or at least very clear interpretations and expectations on how to apply this kind of thing. So I don't know the extent to which this can be useful for the GDPR, but it's something that it's in place. Thanks.
Any more ideas? Of course, this is a question that very effectively resumes the intention of this panel. Of course, it's a very ambitious intention. Personally, Inge, go ahead.
Yeah, so no, I indeed very much agree with your impression that certain aspects of these models work well, and there is also various reasons why certain elements were chosen which might not work for the other areas. Some of them are legal, some of them are also political. So I very much agree with your idea of working from the strength of certain models and seeing if we can transpose part of them to the GDPR, for instance. And there, I definitely see the advantages of a more centralized model, but looking at the competition experience, having a system of parallel enforcement and the European Commission and the national authorities really requires good coordination. And there, I think what you explained about the banking system, that there is this division between significant and less significant entities that have to be regulated, that this is used sort of as the way to decide who is competent, and we don't have something like this in competition law. So this could be one way to think about trying to have a division between the centralized agency and the national authorities. And in this sense, maybe also the Digital Markets Act, which focuses on gatekeepers, gives the competences for enforcement to the European Commission, could also be an interesting test case, because beyond that, we still have the national competition rules applied in parallel. So let's see how that exercise works out in the coming years.
Indeed, in my list of questions, there was also the comparison between models which work with thresholds, like in merger control, in the recent Cpc Regulation, we have certain infringements, but unfortunately there's no time for that, and I'm really sorry for that. But I thank you for your attendance, and I especially thank all our panelists for what has been a very fruitful discussion. Thanks a lot.